Hello everyone. My name is Shivangi Tiwari and I'm from Hidayatullah National Law University. In today's video, I'll be dealing with jurisdiction under Indian Penal Code. So the topics which shall be covered under this video are: firstly, we'll be dealing with extraterritorial jurisdiction, intraterritorial jurisdiction, Admiralty Jurisdiction, and lastly we'll be covering effect of reading section 3 and section 4 of Indian Penal Code with section 188 of Criminal Procedure Code. So firstly, what is jurisdiction? The word jurisdiction refers to the practical authority or dominion which is conferred upon a legal body so that it can administer justice within that defined field of authority. So the Indian Penal Code deals with intraterritorial jurisdiction and extraterritorial jurisdiction. Section 3 and 4 of the code deals with the extraterritorial jurisdiction of the code, while section 2 of the Indian Penal Code deals with intraterritorial jurisdiction of the code. It makes the code universally applicable on all the persons for every act or omission contrary to the provisions of the code. Here, according to section 2, every wrongdoer is made liable for the punishment with the intraterritorial jurisdiction of the code without any discrimination on the basis of his nationality, rank, caste, or creed. The only requirement under this section to incriminate a person is that he should have committed the act or omission within the territory of India. However, there are certain exceptions to the universal application of the code, which is provided to it by the virtue of section 2 of the code, and therefore some specific people are immune from the criminal liability. This class of people include foreign sovereign, diplomats, enemy aliens, foreign armies and warships, and presidents and governors. So now we'll be talking about section 5 of the code, which is an exception to section 2. The section 5 of the code provides for limiting the jurisdiction of the Indian Penal Code by excluding the application of code over the matter for which specific laws are already present. It limits the applicability of law on specific class of people for whom different laws are already present in the country. Now we'll be talking about the extraterritorial jurisdiction, which is conferred to the code by the virtue of section 3 and section 4. So according to these sections, a person can be held liable for any act or omission which he has committed beyond the territory of India. So according to section 3 of the Act, any person who commits an act beyond the territorial limits of the country, but the repercussions of such an act which is committed beyond the territory of India are such that it is committed within the territory of India, then such a person would be dealt with in accordance with the provisions of the code for the act which he has committed, which is contrary to the provisions of the code. And then section 4 of the Indian Penal Code expands the ambit of application of section 3 of the Act. And according to this section, when an offender commits a crime or an offense outside the territory of India but is found within the territory of India, then there are two courses of actions which can be resorted to by the government of India. Firstly, there could be extradition of such a person. So what happened in extradition is such a person is sent to the country where the effect of his wrongdoing took place. Secondly, extraterritorial jurisdiction is the second course of action that can be followed, under which he can be tried in accordance with the criminal laws of India. Next, we'll be dealing with an important topic, which is Admiralty Jurisdiction. So, Admiralty Jurisdiction is the jurisdiction which confers the power to try offences which are committed on the high seas. So, incorporation of Admiralty Jurisdiction into the Indian statute was a result of various charters of British statutes. The notion that a ship which floats on high seas is like a floating island is the basic principle behind the Admiralty Jurisdiction. The extension of Admiralty Jurisdiction is over the cases which involves the certain offences, like first the offences which are committed on the Indian ships on the high seas. Secondly, the offences which are committed on foreign ships within the Indian territorial waters. Now we'll be talking about the effect of reading section 3 and 4 of the Indian Penal Code along with section 188 of the Criminal Procedure Code of 1973. So according to section 188 of CRPC, when a wrong is committed outside the territory of India by any citizen of India, either on high seas or elsewhere, or by any non-citizen on the ship or aircraft which is registered in India, can be made liable in accordance with the provisions of Indian laws as if the offence has been committed by him within the territory of India. The section 3 and section 4, when read along with section 188, form a class of law which deals with the trial of a person who has committed any act or omission outside the territory of India, but that act or omission has resulted into a wrong in accordance with the provisions of the laws in force in India. Section 188 mandates the prior approval of Government of India for the trial of every wrong committed outside the territory of India. So that was all for today's video. I hope you find this video helpful. Thank you.